All right. I'm just recording and observing today.
Excellent work,
Uh,
gentlemen.
All
it's just
right.
for documentary purposes. Have
Oh,
fun and enjoy
how
the
are you?
show.
What's your name?
Doing fantastic. David
Speak with
Kensington's
your
my name.
goddamn chest now.
Sorry,
Is this guy
David
a
Kensington's my name.
There
Nice
you
to
go,
meet you.
big guy. There you go, big
Is
guy.
this guy a ventriloquist?
Nice to
Why?
meet you.
Nice to meet you. What's your name?
I'm Vito Pafano, Justice for Civil Equity. Am
That's
I right?
fantastic. Pleasure to meet you.
Otter Wilson, City Council.
Justice Paul Castellano, Court of Review.
Nick Adams, State Attorney's Office.
Wow. Pleasure to meet all of yours. Pleasure to meet you.
All right, let's just get over with some formalities. What is your state ID?
Oh!
Oh,
Sorry,
please don't hit the nice lady.
No, there was a fly on the chair, and I was
Oh,
like, this is
alright.
absolutely, utterly disgusting here. Sorry about that one. It's 7954.
Jesus, that's high.
7954. And before I look at your profile, is there anything of concern that might hinder you from going on with this process?
I hope not. No.
All right, Mr. Kensington. It looks like you're not lying to me. You got nothing on your record.
Not yet. Should be
He's too
just
Not
fine.
clean.
yet. Oh,
Excuse me.
may I ask, what would be on their record?
You got some plans going on? Tell me-
Possibly in the future, on my record, it'll say, Mr. Kensington, Magistrate of the Court. That's what I'm trying to
Oh,
get
there
at,
you
you know?
go.
That's what I'm talking about.
Oh, this
Yeah,
guy
baby.
just five-headed right there.
All right,
that.
Mr. Kensington. Do you currently own or hold a bar license?
No, I don't, unfortunately. No, I
All right.
don't.
Have you ever held one in another state or have worked as a functionary for the courts?
Yeah, I have held bar licenses in the past. I've worked as a prosecutor,
All right.
as well as a corporate private attorney as well in the past. So I've kind of had both sides of of uh, of the aisle in my experience. So that's I've had the chance to do that in the past.
Fair
So
enough.
you're telling me that you're pretty experienced, huh?
You know, if that's what you want to describe it as, for sure, I'll take your word for it. If you think so, that's for sure.
I mean,
guess
you're
everybody has their
on
own
the left
experience.
side, you're on the right side. Now you're trying to be in the middle side. Come on,
Yeah.
I mean,
Yeah,
two
you
and
know,
two
I love
equals
the
4.
courts. I love to be here. I love to be here. So I really just want to contribute to the court in another aspect. I feel like I've built up my experience. Now I can, help out in any way, shape, or form.
Why
I've
now,
heard great things.
Mr. Kensington? Why now?
Let me tell you, listen, I'm getting too old for this whole corporate stuff. You know, that's the last thing I did. I'm getting too old for that. It's too many of these youngins and IT stuff. I don't really want to have to do with any of that anymore. And when it comes to
Today we
to
just
this part,
observed.
now, I feel like I want to go out in a bang. Now, see, don't take that literally. Don't take that word for word. No actual bang. But I feel like ending as a judge, that's really just the pinnacle of any lawyer. Like that's the dream of any lawyer. And see, in my case, that's the way it is. So that's why right now, this is where I want to retire.
Okay, okay, fair enough, fair enough. Good answer.
I can resonate with that. It was one of my reasons why I became a justice here.
These dickheads.
All right, but you do not currently own the bar.
No,
So?
I was inquiring about it. I was thinking about it, but then I was told by Justice Vance that I should just wait around for these interviews because it would be implemented in the process.
Correct.
You're gonna go from 0 to 100.
0 to hero is what I like to describe it
So
as.
how about you tell us a little bit about your experience and your knowledge from your point of view, rather than us asking you questions, just to start off on why you think that you deserve this position.
Paul's going hard. I like it.
You know,
Yeah, that's good. That's good.
In line with you not possessing a current bar license, and you coming in and saying, I know what the fuck I'm doing, and I want to be a part of the justice system.
I'm be honest, that was ballsy of you because if you fuck up now, it's game over, buddy.
Yeah, I want to hear. I want to hear why you think that you deserve a shot with the San Andreas Bar Association and the judicial system of San Andreas.
Yeah, sure, no problem at all. Well, let me tell you, I think the better question is why not? You know, why not? At the end of the day, one of the most important things as a courts is we're given everybody here, everybody in the state, we're giving them a fair chance to either defend themselves or perhaps we're trying to help other people get closure due to what's happened to their families and whatnot. We need these people. We need them. We need experienced people. We also need new people. You know, I think the bigger the better is a saying that I've learned to adapt in my life. You know, I'm not calling myself bigger here, but I'm someone who has experience. And I think I'm just as equal to the court of law as somebody who's fresh out of law school, who just got their bar license. You know why? Because everybody's an equal. And honestly, I think a lawyer fresh out of law school can beat a lawyer who's been a lawyer for the past 25 years. But at the end of the day, we're not doing it to win. We're doing it for the people. We're not doing it for the money. We're doing it for the people. So we need these people, right? It doesn't matter if you score some lawyers right now or if you score some magistrates. It doesn't matter. It doesn't matter if you need them. You can never have too many, but you can have too little. So let me tell you, why do I deserve a shot? I think everybody deserves a shot. And I'm not going to say and stand on a high horse and say, well, because I have all these years of experience, that's exactly why. I'm not saying that. You don't need me because of that. You just need me because I have a passion for it. That's why I deserve it. Not because of this experience, but I have a passion for it. I love what I do here. I feel at home. This is the first time I've been in this courtroom here, but I feel at home already because I love this. I have a passion for it. I want to do this every day. And I think that's the type of people that you need at the end of the day. So my experience, it just complements the passion on top of it. You know, I've had as we've spoken about, both sides, left and the right side. We've had both of those experiences. I know how to prosecute, beyond a reasonable doubt. But I also know how to play with the preponderance of evidence at the end of the day. And I know the difference between, we know how to work with these two different things here. And I think as a magistrate, as somebody who oversees these at the end of the day, this experience is not invaluable or irrelevant in any way, shape, or form. So if you had somebody straight out of law school coming to you, hey, and you ask them the same question, why do you deserve a chance? He'll say, because he has a passion. And he's right. But maybe the right position wouldn't be throwing him straight on the bench. Maybe the right position would be to throw him either to this left table or to this right table. Build some experience there. Build these little Lego building blocks, and then eventually you can climb your way up. That's just my personal opinion. I think it's my passion. That's why I deserve a shot here.
Okay.
It's not anything else. And the experience, it just complements it. I think that's what you'll appreciate about me at the end of the day.
Okay. Fair enough. I like your answer. Now, before we begin, I have a few questions, but I want to open it to the panel. Should I begin, or does anyone have any pressing issues or questions that they would like to start with?
Well, considering the fact that he is of a higher echelon and he's done both sides, I think we can just do the lightning round for legal jargon to get that out of the way.
Okay.
I have
All
a
right.
question.
You sure, Miss Kyle West?
We have a question from Clerk Miss Kyle West.
Nice to meet
How
you.
strong is your backbone?
How strong is my backbone? Well, my doctor might give you a different answer from me. You see, my doctor might say, you might be struggling there, Kensington, but I'll tell you something. My backbone, excuse my French, but that motherfucker's been the strongest it's ever been. It's the strongest
I
it's
only
ever been.
ask because every one of us in this very room right now has dealt with some of the most dumbest, most craziest, most insane cops of this city.
Oh,
And as a judge, you're going to face a lot of them most of the time. Some of them may even scream in your face without even thinking twice. So my question is,
hold on. Cops, criminals, the whole 9 yards. It's not only police officers who scream in our face.
but I'm just giving him
for
the general
judicial,
gist.
from us judges, we're not faulting the police officers from standing their ground. We get it from everyone. But Miss Kyle West, you may continue.
I'm only asking because as a judge, you got to be on your very much toes. And someone like me who falls in the middle, I just like breaking backs. So if I came with my nice heel, you think your back would be strong as steel or weak as
Are you
I don't
trying
know.
to step on this man?
Yeah, I'm confused where we're
No,
going here. What's
I'm
this
trying
line
to
of-
see if he has a backbone because like Paul says, as a
Oh.
judge,
Oh.
okay,
How about this? How about this, Mr. Kingsington? I have a follow-up question that will help
Sure.
solidify Miss Kyle West's. I think would help solidify Miss Kyle West's question.
Mhm.
You make a ruling on a case, right? Pretrial motion. The prosecution, which is the state, in this specific scenario, has a compelling argument, right? Defense raises a question that is legal and has 4 grounds to stand on, 4 pillars to stand on, and you rule that the defense, their motion for dismissal is applicable and lawful, and you state at your verdict, right, of the motion. Hey, I'll stick around for any questions or concerns that any party has, right? And
Sure.
of course, in this situation, Mr. Kensington, the plaintiff or the state is going to come up to you and they're going to ring you out in so many words, right? They're going to say, "Why did you rule like this? What did I do? What did we argue wrong? How did we argue it in a way that you didn't get our point?" Et cetera, et cetera. Do you understand what I'm saying?
Yeah.
So how would you have a backbone and be confident in your verdict, and how would you explain it in any type of verdict given, right? Whether it's a motion to dismiss and you agree with the motion to dismiss, or whether it's a motion to compel and you agree with the motion to compel, whatever it is, how and you have someone ringing down your back saying, "I don't agree with this, and this is unconstitutional. You are a terrible judge. I'm going to file a bar complaint," et cetera, et cetera. How would you deal with this police officer, or how would you deal with this defense attorney or state attorney when they're ringing down your back and giving you a gaping hole for a new asshole?
Well, sure. I mean, me personally, I think I have a very empathetic position on this, because I think the most important thing for any judge and magistrate in this position is, while you stand your own ground about your own opinion, your own ruling, at the same time, it's not wrong to really sit there and have some empathy for this person that's, perhaps they're coming at you in a way that's not the best way. But I think I would be quite empathetic about it. The reason being is, I'll explain it to you right now, judges, simply because when I sit there, I have on the right side counsel, and on the left side I've got counsel as well. And they've been preparing this case for weeks on end. They've put in hours of work in it. They've been talking to witnesses, and they've been preparing witnesses and all sorts of stuff. And now they get a ruling that's not in their favor. That's a problem. That's a problem. Everyone's gonna be mad about it. It's a human reaction. At the end of the day, we're humans, right? The letter of the law is the letter of the law, right? We've got the rules, and it's, the way it is the way it is. And the
How
rule
would
is
you
the way it is.
respond to the guy who, the state attorney or the police officer representing the state, or whatever it may be? He comes up to you in the chambers behind us, and he says, "Explain your ruling. Explain how I'm speaking for their terms. How in the world would you come up with this verdict with everything that was presented to you today?"
Very simple.
There you go.
I'd sit down and it may sound as a stupid answer to your question right now, but I'd really just sit down and really just explain it to them. Truly, I mean, I know a lot of judges, they might not want to take the time for it or whatnot, but I sit there and I come to the conclusion. I explain to them why this and that, X, Y, and Z perhaps may have overtaken them in this court of law. Perhaps the defense had a more reasonable argument. They had the documents, they had the proof that you didn't have, or perhaps
okay.
you weren't able to meet the burden of proof for this case in this certain situation. Whether it's civil or criminal cases, it's different. You gotta explain it to them. I mean, I'm fond to explaining to people why something was wrong, and perhaps if I know it's a new attorney, perhaps I could tell them, hey, maybe next time this and this would be good, or perhaps maybe next time this and this would be good. It's a difficult one to explain to you, Judge, but really I would try to, I like to have an open door policy and really just explain to people how my mind works. And, I would, at the end, I would leave it off with the classical answer that, and not in a bad way at all. I would leave it off with saying, hey, if you do not agree with this ruling, I'm a person. Perhaps I have made a huge mistake. I do not think so, and I believe this one. And I've explained to you why I don't believe I've made a mistake. If you do think I've made a mistake, I'll point you in the right direction to who to reference or where to open the appellate courts where you can find to go ahead and just appeal this. You know, this is just the way it is at the end of the day.
Mr. Kingston, I know I'm not supposed to give you any advice or it's not in my purview to give you any affirmative answer, but I think that you answered that question very, very clearly and very professionally. Well, let's move on to another question from the panel. Very good job, Mr. Kensington.
All right, Mr. Kingston, gonna have 4 questions for you. We're gonna start off easy. It's gonna get a little bit more difficult. Kind of going back to what Anastasia was doing, you know, testing the backbone.
But yeah,
All right, first question. Throughout the entire courtroom, do you care more for justice? Do you care more for fairness? Or do you care more about your dramatic final verdict?
well, to be honest, I feel like you've just used 3 words which are synonyms for each other because the justice is fair and the verdict is part of the justice. It's all just justice. What you've said there is all equally important because it's all one thing. The justice is fair. It's not unfair at all. We're here to make it fair. That's what justice is. And at the end of the day, the last part there, my verdict, that's how I deliver the justice in whatever way that may be. So honestly, I may have to give you an answer you might not like, but I'll be honest, I think it's all the same thing. So it's all
I love that.
equally simple.
Every applicant's answered that differently, but yeah, that's good. Next question. You're in a high-profile trial. You're in the courtroom. You're looking out the double doors. A mime walks in and claims he's the culprit. What's your move?
What's my move? And sorry, you said so who walked in?
So you're dealing with a high-profile trial. A
Yep.
mime walks into the courtroom and claims he's the culprit. What are you doing next?
But don't mimes not talk?
I didn't say he talked.
Oh. How did you
Charaded.
claim
You
it?
know the information now. What do you do with it?
Gotcha. Yeah, I'll be honest, you want. First thing I would do is I'd go ahead and I don't know. I want to know how we got in high-profile cases. Usually, in my experience, those are usually, you know, it's hard to get into the case. Usually, we got closed doors there. But if he got in and you know past security or something, firstly I would get a sidebar, and you know I would take it for into consideration. I talked to the prosecutor. Hey, prosecutor, didn't know this guy. Defense, you know this guy? Anybody know this guy? And depending on perhaps if they know him, then we'll get him involved in the case in some way, shape, or form. There's no problem with that. Obviously, there'll be objections here and there coming around. But at the end of the day, I think if something came in and somebody, you know, this does happen. This is a serious situation. Perhaps this person has some relevant information for the courts. We'll throw them to my right side, and perhaps they can make a statement on it. Some questions may be asked, but that's only if both counsel obviously agree to it. But it's a complicated situation, I'll be honest. But I think it requires communication with all members and officers of the court to really come to a great conclusion here on this one. But perhaps I think I would not, if what you're getting at here, I would not exclude possibly involving this person in the court of law, because maybe this is the person who really did the crime. Maybe this really is the culprit. And at the end of the day, we want to get justice served. If that's the way we got to go about it, we go ahead and take in all the information we can.
All right, I like it. I was going to ask 4 questions. I'm going to cut it down to 3. I'm going to ask one more, and then I'll pass it along to the next person in the panel. You're in the courtroom. You're giving your deliberation. You're giving out the final verdict. How many ums are you going to say from start to finish?
Oh, God.
None. I'd hope so. I tried to get rid of that habit when I was about 19 years old, so I'd hope there'd be no ums at all, because that kind of gives off some insecurity. And that's no offense to any of you that may say, that's a perfectly normal thing at all. It's just us thinking out loud. But, I know it comes off as a little bit of insecure, but when you're giving your deliberation, you really want to be secure with what you're saying, and you want to have everybody else perceive that as well to really get make sure everybody understands that this person here delivering a verdict is, unsure about what they're talking about. Get what I'm saying?
Get it 100%. Appreciate your time, man. Thank you.
Yeah, thank you.
All right. Since we didn't get to start off with the legal questions, as you don't retain a bar, I'm just gonna do a lightning round. All right, you ready?
Yep, hope so.
Yeah, you hope so. All right. Are you insecure?
Ah,
How confident are you on a level of 1 through 10 right now with your legal analysis?
my legal analysis.
1 through 10.
Let me say, 8 because there's always room to learn. 8 because there's
Sure.
always room.
All right, Mr.
Well,
Pravano. Justice
let's get on
Pravano,
to
let's hear it.
All right. What's the difference between probable cause and reasonable suspicion?
Oh, probable cause is having the concrete, whether it's physical or in an officer situation, direct witness evidence of a crime that may have been committed, while reasonable suspicion is the presumption, the gut feeling of a crime that could have or has or is about to be committed.
All right. We're moving on to amendments. What are the first 10 amendments to the U.S. Constitution? What are they called? You don't have to name
First-
them all yet.
But fucking got freedom of speech there, right to bear arms.
Yeah, but what are the first 10 called colloquially?
There you go.
Colloquially.
Yeah, what's the term
group-
that's given for
the
the first
group that
10
they're called.
amendments?
Oh, there's a. Well, honestly, I couldn't tell you. Honestly, actually, I have to be open honest. There's a group
Starts
for
with
them?
Bill.
Oh,
It's a
Bill of
paper.
War.
Bill of
Yeah,
Rights. All right.
That's right. That's what I said. Yeah,
Yeah, First
I
Amendment. What
thought
is
I heard
it?
Yeah, freedom of speech. And
All
media and all
right.
sorts of stuff.
Third.
Third is no force quartering of soldiers.
Correct. Second.
Right to bear arms.
All right. Fifth.
Right for due process, double jeopardy, any of that stuff, or self-incrimination.
Correct. Fourth.
No unreasonable searches or seizures. That's right. Yeah, I'm right. I'm right with that one. I'm confident on that one.
All right. 6 and 7.
4, 6 is my favorite one. Speedy trial. Speedy trial. Love that one. Speedy trial.
There's more components to it.
And the jury, obviously. Public trial, so by jury for criminal cases.
Correct. I'm looking for one more.
For the 6th one, Speedy is a key components. I remember Speedy, public trial, by jury, criminal
Probably
case.
the biggest one of all.
God, help me out here. Where am I looking here for 6-1? Speedy,
Speed and
speed, and finish the sentence, Judge. Finish it. Come on, you got it. I know you
You're
got
not
this
phoning
one.
a friend.
what is everyone entitled to? They're entitled to a speedy and
Fair trial.
blank. Okay,
Speedy and fair trial. Is that what you're looking for?
that's what I'm looking for. I don't know about Mr. Justice Pravano.
You
What
also
right
need to
do
know
you
your
have?
accuser. You have the right to know your accuser.
Oh,
right.
Gotcha. Right to be. Yeah.
And cross-examined.
All right. We're moving on to case law. All right.
God, case laws. You're really gonna be itching the back of my brain for this one, but I'm ready
All
for it.
right. Terry v. Ohio.
The famous Terry frisk is offers the ability to go ahead and stop somebody, perform a search, a frisk, so to say. Somebody based
All
on
right. What do
reasonable
they
suspicion.
need? All right. Good.
Unlike
Pennsylvania versus Mims.
Hold on. Justice Pravano, I'm gonna step in here. What does an officer need in order to conduct the Terry vs. Ohio frisk? As
You just said it.
reasonable suspicion.
well, you need reasonable suspicion. What else? Along with reasonable suspicion, a lot of attorneys that come in our court don't understand this. They don't articulate it. I should say. They need to believe that the individual is what?
They need to believe that they will commit a crime or have committed a crime and they're presently armed and dangerous
Yes,
for the general
there you
public.
Yeah,
But to be
that's
lawful.
reasonable suspicion. But this is a crucial point that a lot of individuals don't articulate, including police officers don't articulate.
Isn't it the part where they need to be where you need to have the presumption that they're presently armed and dangerous, which would be
There you
buffer.
go.
But
There you go.
All right, go. Chad.
which in the state of San Andreas, right, as a defense attorney, how would you, as a prosecutor, I want you to argue how, really quickly in a paragraph, how would you argue that a typical citizen of San Andreas is armed and dangerous, whether implied as or in fact armed and dangerous?
And in this situation, do I have the officers have reasonable suspicion or literal probable
Yeah,
cause?
they have reasonable suspicion that the person committed a crime, has committed a crime, or is about to commit a crime.
Whatcha?
But how are you going to articulate that they're armed and dangerous? That is the second part that you need in order to conduct a Terry versus Ohio frisk.
Giving me very situation dependent question here, Justice. I'll be honest. Perhaps maybe the other applicants are better with this one here. But I guess can I ask one more question just for a scenario? Because I could articulate it in 1,000 different ways, but the real question here is, it's easier to articulate if the officer literally saw the person, perhaps have a firearm, a bulge, or saw the person have a firearm or something such, or saw somebody have an object in their hand, but they wasn't sure if it was a firearm or something such, or if they just didn't see anything at all and it's just a person that's
Let me just ask you this: Let me just ask you this, just to
Yeah.
speed up the interview.
Yeah.
Would you agree with me that most people in the state of San Andreas are armed?
Sure, yeah.
Most.
In my experience, yeah.
Most, as in being more than 50% of people that you stop as if you're a police officer, more than 50% of the people that you stop are armed, correct?
Yeah, I'd agree with you there, Judge.
Okay. And if you are a police officer, more than 50% of the people that you stop, whether for a traffic stop, whether for infraction, detainment, misdemeanor, or felony, more than 50% of the people are dangerous based on their actions that they take upon being intercepted by police officers. Would you
Sure.
agree with that? Okay.
Sure, sure, yeah.
Based on what I just said, how would you articulate a typical individual being armed and dangerous, or the presumption as a trained police officer of the individual being armed and dangerous?
Sure. Well, the situation, Judge, it's very simple. I mean, based off of probable statistics that we come across in the court, I mean, as we know, we know there's individuals around the state who have firearms, and when they're actively committing a crime with said firearms, they've already shown a certain amount of negligence to the actual law. If they're willing to run from the cops, if they're willing to bust through red lights, go through intersections at 180 miles an hour, and put other people's lives at risk with their car already, what makes us believe that they wouldn't do so with a firearm? Because what's the difference between getting shot or getting T-boned at 220 miles an hour in the middle of the city while there's somebody being negligent with the way they're going about and not following the law in any way, shape, or form? So in this case, I believe it's reasonable to believe that if they're willing to commit those crimes, if they're already going to these felonious extents of committing crimes with another object that's not a firearm, but they're doing so while they're possessing a firearm, it's reasonable to presume that this person is already dangerous, but now they're armed and they're dangerous. So perhaps they might escalate to some more. That's how I phrase it.
All right, did you get your answer, Paul?
Believe me, I think that is a fantastic answer. Thank you.
All right,
I have more
moving-
questions, but I'll let you guys finish.
Sorry, Judge. Do
Yeah.
you mind if I just go stretch my legs real quick? Just get a little tired. I gotta go speak on the
Sure,
back.
go take a 5.
Thank you.
All right, let's go deliberate real quick on the last few questions here.
Ooh, sorry,
right in the
sorry,
back.
Jesus
sorry.
Christ!
I didn't mean that. I didn't mean that. I swear to God.
I know the
All right,
state
we're gonna
attorney
go
isn't
do a
offended,
little bit
but
of
damn.
retooling for our questions. All right. Don't know if you heard us, but tell them we'll be out in like 5.
What do you think of it? Vance. can't. Hello, Bounce.
Hello. Why were you on my lap? Hello?
Sorry. What do you think of that one? Or you fell asleep during that one?
No, that's not what happened. But I'm just paying very close
Here,
attention.
please.
No
Wait right
problem.
here, please, until they come out.
Yeah, no problem.
Why were you not up on the panel today? Oh, you was tired from last night.
No, I had a case. And I thought it would take longer. We were
Oh,
having
the
court
one
upstairs. What do you mean?
I was literally busy having a life before today because I'm not want to be awake.
We were in court upstairs. Luckily, the state did not wish to contest the appeal. It was very quick. The only reason I
Okay.
recused myself from the panel is because I thought I wouldn't have time to get here. And didn't want to
Oh, okay.
delay this because of it.
It's within reason. I was just doing some, house decorating. I just got someone to. I just put my house up on the market right now.
Oh, that's nice.
Yep. Oh, by the way,
Plus,
how
I feel
does this
Paul.
chain look on me?
I feel Paul brings like a fresh air to things.
I feel like last night
chain
was
is
fun.
beautiful.
To be fair, thank you, Tommy. I feel like last night was fun. I'm not gonna lie. You don't get moments like that in the city too much.
No, you don't. And that's what
Last
we need
guy
to do
was
more of.
yeah.
We just, we need to do more of those things. I want to do a DOJ, like, what's it called? Q&A.
Mm-hmm.
But it's like in a bar setting. I don't know if you know about the pit, the bar there by the old courthouse.
Oh, McLaren's.
Yeah, I think that's it. Be there with a
Yeah.
bunch of fucking drinks and people just ask us legal questions and ask us about the DOJ. Or we just,
That'd
if
be nice.
we get bored of asking boring questions, we just drink all our worries away
Hell yeah.
and have a
Right.
good time. That's what it's about.
I wasn't. I was like, I forgot. I almost forgot about this, but I said like I was just wanted to be, do some stuff for me today. Have a me day. If we don't have anyone else after this,
Yeah,
I'll probably go fishing.
tomorrow is gonna be a me day, and you'll most likely not see me at all.
Sundays is usually I stay in my house with my husband day.
Yeah, no, tomorrow's gonna be a me day, and then I'll see. Today is this, the case I just did, then witness to the appeal coming up after storm, and it's a busy day.
You think I have enough time to go fishing after storm then?
It's an hour after storm.
If the weather does not be fickly.
I mean, I don't really know much about fishing, Miss Kyle. I personally despise the idea of doing so.
I just do it because it's easy freaking money.
I mean, currently, let's see. Ooh, 11,000. I can go buy a VV.
No,
Why?
no VV. You
Only
already have
one.
enough.
I want one. I don't have them all. It's like Pokemon. I gotta catch them all.
Stay right here. Let me see if we could go. Knock knock.
Almost done.
All right. I'm gonna take Helen to go buy a stupid VV. Do you need anything by chance?
Food and drink, please.
Already got you covered.
All right. Appreciate you.
We'll
Give me
wait.
one more minute,
Yeah.
and we'll do the exodus for you. All right.
We'll
I
wait
got
till
you,
this is
Bozo.
done, Anastasia. I actually am watching and paying attention.
All right, no problem. Go buy you a little stupid VV shit.
Well, it's either that or all on black.
I the VV thing. Okay. Jesus.
I heard I can spin a wheel and win a car. Do I spend 5k on a VV or a wheel spin?
Call it right now. Even it will be VV. Odds would be a wheel spin.
Yeah, go for it. Yeah, I'm getting a VV.
All right. You can step forward here once these guys get out here. Are you good? You well rested? You took a lap?
Yeah, I'm all good. Thanks, Judge. Appreciate it.
All right, good. What are they doing back there? The hell is that in your hand? I don't need these.
No, you're good. Totally good.
Alright, you can have it. Alright. So we're gonna ask you two more case law questions and we'll move to two scenario based, alright? You
Gotcha.
ready?
Yeah, sure.
Alright. Tennessee versus Gardner establishes good faith. What is that?
Yeah, Tennessee v. Iguana. Probably the most important one and the favorite one for the corpse. Do you want me to go ahead and give an example or just explain?
Explain what good faith belief is and how it relates to this case in particular.
Okay, sure. Yeah, so good faith belief in this situation here is that an officer needs to have use the term good faith belief that a suspect poses some sort of significant but deadly threat to the public by his or her actions, or I don't know, perhaps in certain situations what they have done or what they or could be doing here. Perhaps they're running towards a public road with a firearm or something such.
Mm-hmm. Well, what is a good faith belief?
It's a reasonable belief based off something that can be articulated based on personal. How do I phrase this here? Something that can be articulated based on evidence. In this situation, evidence witness from an officer.
All right. And then Wyoming versus Houghton. What are the main doctrines that are presented in that case?
Yeah. Wyoming, Houghton, Wyoming. It's a very nice one. This one's very good. I like this one. Uh, I'm not thinking about what it could be. Let me just scratch the back of my brain and keep thinking. Honestly, Wyoming v. Houghton. Wyoming. This is a very good one, Judge. I want to see. What made you choose this one here?
It's something that has been Paul, you have something?
And he's deflecting the answer back to you, Mr. Justice Pravano.
I'm also curious about. I'm a curious man, so I really like. I like the.
Let me give you a hint here because I think that you need a hint.
Sure. If you wish to do so, Judge.
Yeah, I'm gonna help you out here. It has to do with vehicles.
Yeah, of course, obviously. Wyoming v. Houghton, the most important one, where probable cause is something that officers can use to go ahead and search vehicles and can also inspect what the passengers' belongings. It's not just the driver, and that's one of the most important case laws that we use in very many cases. Judge, would you agree?
I would agree that's for Carroll v. United States.
Wait, sorry, say again. What about Carroll v. United States?
You articulated the case law for Carroll v. United States quite well for vehicle search.
I guess I'd
They
rephrase
cooking
that one
his
actually.
blind.
Carroll v. United States.
Actually, I want you to explain your original question again, and then move on to what Mr. Justice Pravano gave you some feedback on. If you don't mind, explain your initial answer, and then move on into Justice Pravano's feedback, if you don't mind.
What was his feedback? Oh, move on into US v. Carroll. Is that what you want?
Well, he mentioned to you. Well, he would agree with Carroll v. United States.
Gotcha. Okay, let me go ahead and explain Wyoming v. Houghton again, and then
From your point of view, and your understanding of Wyoming v. Houghton, I'd like you to re-explain your answer and why you came up with that initial answer, and then move into Carroll v. United States, if you are able to. Which is okay if you can, which is fine.
Sure, no problem. Let me articulate this one again. So, Wyoming v. Houghton. So, what I covered, what did I tell you? I tell word for word. I remember telling you. I said officers with probable cause are able to search vehicle, right? They're able to search a vehicle. The most important one, off the top of my head, for Wyoming v. Houghton, is the inspection of the passenger as well. Because I remember there being a separate case law for the passenger, apart from everything else, because usually that's different, right? That's passenger's not really correlated. It's the car's not registered to them, anything as such. So the passenger here, it's the inspection of what the passenger has on him based on probable cause, with the presumption that perhaps they may have something that we're looking for, and they're the ones concealing it because they know that they're usually
There's the buzzword.
until this case law existed, right? Officers really weren't able to touch the passenger. So people knew their rights. So they would use the passenger possibly to go ahead and have that key thing we're looking for in the passenger. So that's why.
Is it all passengers or just the front right side passenger in the state of the United States, or in the country of the United States?
Good question. All passengers, Judge.
Okay.
And that's why this case law was introduced, and this was relatively late for the traditional case laws. I don't remember what year, but it was relatively late, and it came around, and then it gave officers the ability based on probable cause to find that thing they're looking for, because the passenger could be an objection to the search. You know what I mean?
Concealant.
That's right, concealant. That's
Okay.
what we're looking for. And then
Now,
moving
what about? Sorry to cut you off, but what about Justice Profano asked you about Carroll versus United States?
Yeah, sure. Carroll v. United. I would actually, the way I phrased the first one, Judge, I'll do something risky here, and I'll actually disagree with you. The way I phrased it would be, I feel like, disrespectful almost to Carroll v. United States. It's such a beautiful case law. But I think the most important thing about it is simply that the key point is that it's the automobile exemption to the Fourth Amendment, right? Because we know cars can move. They can go from A to B. So it's easily for this evidence to be able to be transported away, transported across borders. Officers would be unable to do anything at all, right? Because it's a car, it's not a house. So, in a house, it may be there.
What
right?
about an RV?
That's a really good question. It's still a car. I think
I
this.
know. I can sense what you're getting at and what your thoughts are coming from. That's why I
Sure.
ask you. What about an RV?
Yeah, that's a very good question. Well, I think that depends on where the registered address of the person is. If it's not their actual registered address, it cannot be considered their house. So it would be considered a car because it's mobile. Well, at the end of the day, an RV is an automobile car, van, truck, whatever you want to call it. It can move across borders. And I would agree here of my personal interpretation of this case law that RV would still be part of the automobile exemption.
All right. That's
All right.
the only follow-up questions I have for Justice Provano's questions.
All
I yield
right, we're
back at
gonna
this
do
time.
a simple scenario question from me, and then I believe Mr. Castellano, you have one,
Yes, sir.
and Mr. Nick, you have a question after him, and then we should be concluded here.
Yes, Judge.
All right. Your scenario question is this: an officer is parked in an area that a crime happened recently in. They see a vehicle pulled out of an alleyway nearby, and decide to pull them over. Why is this an illegal or legal stop?
Okay. Interesting. It said, sorry, can you just repeat it? Let me write it down here if you don't mind. So I have one.
Sure. You gonna write this one down?
Yeah, my memory's just, when you say something, I like to have the facts on a piece of paper, I don't like to memorize. That's how you give
Okay.
fair verdicts, in my personal opinion. You have it, you forget
I'll
things.
take
We're
it as
human.
justice. That's good. Good habit to have. So, an officer is parked in an area that a crime has happened recently in. They see a vehicle pull out of an alleyway nearby and decide to pull them over. Why is this a legal or illegal stop? And explain.
Yeah, this is a great judge here. Well, let me tell you. Well, off the I guess vague information I have, I mean, I would say it's unless an officer can articulate on what reasonable suspicion they had that there's a traffic law that had been committed or could have been committed, whatnot. I don't see why that would be a legal stop in any way, shape, or form. Once again, it really based on the articulation of what's the reason for the stop. Is it simply because a crime was committed there? And when he said, and I quote, I believe he said a while ago, and a while is not like 5 minutes, 10 minutes ago. An alleyway, anybody can come through. You have millions of people living in this world, billions of people live in this world. Anybody can go through that alleyway, right? We're in the city as well, I believe you said. Or if it's an alleyway, we must be in the city, right? After all, we got plenty of people there. So, in my opinion, unless the officer can articulate it based on reasons that they had reasonable suspicion that a traffic law has been committed or any violation has been committed or anything of such, that it's an illegal stop, in my personal opinion, Judge.
So you need reasonable suspicion to conduct a traffic stop, is what you're saying?
Well, you can stop somebody with reasonable suspicion. Let me just say that. But if you've witnessed a traffic law being committed, it's already probable cause. So that's different.
All right, Paul, you're the next question.
I got a question for you, Mr. Kingsington. Actually, a question that came across my court of review about 2 weeks ago.
Sure.
Now, let's say that an individual robbed a bank. Multiple individuals, let's say 4 of them. They all hop in a vehicle. They flee from the bank. They're all being chased by police officers, and some of the individuals. They stop on the side of the road. The driver gets out, starts repairing the vehicle, actively repairing the vehicle while the other 3 individuals of the vehicle start shooting active gunfire towards officers. And subsequently, the individual repairing the vehicle was shot out, right? And long story short, the individual who was repairing the vehicle is suing the PD for excessive use of force. Excessive use of force under the Fourth Amendment. Based on that knowledge alone, how would you determine and how would you go forth with your verdict and with the process of hearing the case? More so the verdict, just on those facts. And I want you to apply the Fourth Amendment. I want you to apply certain case laws. I want you to actually speak on how you come to that verdict of whatever you come to, with supporting evidence.
Sure, Judge. Can I ask you just one question? Since you said this was an actual case you had come across your table here, did the person at any point in time that the individual was repairing the car, did they have a firearm? Was they found with a firearm? Did they have a brandish it throughout the whole situation?
All I'm going to say is that there's 4 individuals. They all hopped in the vehicle. They were on an active police pursuit away from the bank. They pulled off to the side of the road. All 4 of them hopped out. The driver of the vehicle went to the front of the vehicle to repair the vehicle and was actively repairing the vehicle while the 3 individuals opened fire on police officers. With that information alone, and with you having a case in front of you saying, I'm the driver of the vehicle, I was repairing a vehicle, and I'm suing the PD for excessive use of force, and my breach of my Fourth Amendment right. With that information alone, explain what case law you would use to support or to defend your opposition with your opinion, and how would you rule on that case alone?
Sure, Judge. It's actually a very interesting situation here. We'll love to see what your ruling was on it later here, if I could pick your brain about it. However, let me tell you here, this situation, I think one of the most important things you have to, one of the case laws I would apply here would, my opinion, Tennessee v. Ghana here. Really important to get this one. Because we were just talking about it earlier, deadly force cannot really be used upon a suspect unless an officer believes that they're going to be significant threat to the public or injury based on what they're doing. Now, this would be interesting. It could be argued in 2 different ways. It could be argued by an officer, perhaps, that the way they were driving, or that they had a firearm, that they're surrounded by other people, that they're an accomplice to the crime of 3 other people that have firearms, and they're helping them as a mobilization unit to get around city. Perhaps that might be a reason on why you would need to neutralize a suspect. Perhaps that's one thing that could be argued. However, Judge, I'm not going to get too deep into that because I think there's 1,000 ways you can argue 1,000 different cases, Judge. However, I think in this simple situation, Judge, well, it's not simple at all. I'd simply say, based off the information that you provided to me, solely the information you provided to me, I do not believe that an officer was able to really provide enough of a reasoned belief that the person that's actively repairing the car,
Thank you.
is threatening. It's in the situation where they're repairing the car, they're obviously not fleeing either. They're stationary. They're not threatening. They're not going anywhere. So I don't believe deadly force is reasonable, and in that way may violate the Fourth Amendment. So in this case, I think a lawsuit can very much be open against the PD in this situation, Judge. Now, how that plays out, that's a whole nother rule, obviously. The way that plays out, whether the officer is going to be found liable, or in this situation, qualified immunity will play around, whether or not the PD will be found liable for their actions or not. That's one thing, Judge. However, in my personal opinion, with the information it gave me, I would base it off Tennessee v. Ghana, that they simply did not have enough evidence to suggest that this person would be a reasonable risk to the public to use deadly force upon them. The force must be objectively reasonable. upon a suspect, right? And you know, most likely that officer shot that person by accident. And if they shot them by accident, you know, that's a reason for a lawsuit on a whole nother basis.
Thank you, thank you very much, Mr. Kingston. I have no other questions for you. Thank you. Appreciate your time.
Thank you for your time.
Mr. Adams, you got a question?
Oh yeah. Sorry, I thought it was back to Mr. Wilson there. All right. So, given the extremely heavy caseload you can face in this role, and whether it's this role or really any role within the DOJ, I want to make sure, since you've gotten off the plane pretty recently, what's driving you?
It's a good question here. Very good question. What's driving me? But I like to touch upon. Sorry, was that the end of your question?
I'll have a follow-on to it, but I'll
Okay.
start with that. I don't want to
Okay.
ask compound questions.
Sure, no problem at all. What's driving me? What's the love of the law? I'll have to go back to it. I'm sorry. I'll have to go back to it. It's the passion. It's the love of the law. That's what's driving me. And I think, you know, a lot of workload. It's not new to me at all. You know, I worked in the corporate sector. That's the workload we get there. Excuse my French. The dickheads we have to deal with there. The rich ones. Yeah, it's horrible. It's horrible. You know, but I'm used to it. I'm used to it. I'll be honest to you, prosecutor. I'll be honest. I'm used to it, and I'm doing my very, very, very best to upkeep the way I was back when I was 25 to the way I am now. And what's driving me really is I know you're hiring, so there's a need for it, and I'll always be there to help other people. I'll always be there to help out of scarcity. That's what I want to do. I want to make a difference. I want to help out. So if you're hiring, that means you need it. So I'm here. I'm here. I'm here. I'm present. I'm active. I want to be there. I want to assist. I want to alleviate the stress from perhaps other judges and other magistrates, reduce the workload, because then we can distribute it amongst more people. That's what's driving.
Okay. With that, how do you manage your burnout? How do you manage burnout?
I don't get burnt out. That's a good question. I don't even get burnt out. That's like asking, how do you recover from a car accident? I don't even get in a car accident in the first place. You know, if you drive careful, sure, other people can be negligent. If you drive careful, if you do your due diligence to prevent yourself from getting burnt out, then you won't get burnt out. That's my personal opinion. That's how you get through law school. Everybody gets quote unquote burnt out through law school. That's because they neglect the other things. They neglect themselves. They neglect their personal development. They neglect going to the gym. They neglect eating 3 times a day. I don't neglect that stuff. I take care of myself. I'm a man. I know how that works. I don't even let it get to the burnout in the first place. And if I know it could, then I'm open and I communicate about it. I say, Judge, sorry, Justice, can't take this case. Sorry, too much. Can't handle this right now. Don't have the time for myself. That's important, right? It can't be. How is it fair for me to judge other people if I myself am currently an imperfect man? If I can't even stand on 2 feet without hallucinating, if I can't stand on 2 feet without hating what I'm doing, that's horrible. Burnout is atrocious. I think we really got to do everything to make sure we take care of ourselves. So I don't even let it get to burnout. I don't know. I don't know how I handle it because I've never been burnt out. I just know how I take care of myself.
All right, that concludes my question. I think this follows into the next question from Mr. Wilson here. So, thank you.
It does indeed. Appreciate it. So you don't get burnt out, but you're willing to let them know that you need some time. Yeah, right?
Yes. Just wanted to get a feel of the courtroom, left and right. So I was missing it. Sorry, Sam behind those tables here. Sorry. Continue. I've been listening.
Okay. No worries. No worries. What kind of antidepressants do you use? You take?
That's a good
What's
question.
your milligram usage?
I don't use any antidepressants because I believe that they affect your judgment. You know, just like side effects. I don't take those. My antidepressant is the sun, vitamin D. I go find it. You know, sitting too much indoors, that's your problem. Go find some sun. Go eat 3 times a day. Get the gym. That's my antidepressant. It's the natural things. I don't take pills. I don't do that stuff. I'm sorry.
No
So
worries.
touching grass.
And one final up. How much D do you take when you're outside?
That's a really good question. I'd actually rephrase that one. I don't usually take D, but when I do get a lot of sunlight, plenty of it actually, I like to kind of get 3 hours of it. But
Hours a day, okay.
yeah, sure.
UV type of guy.
Yeah, UV type of guy. When I see it's UV9, I'm out there just like with all the
Ah,
all
okay,
the
there we go.
girlies with the tanning oils. I'm with them. I'm tanning with them.
Excellent, excellent. Nothing further.
All right, it should conclude our questions, but to let you know, you will have to obviously be elected by the people. So campaigning is something that you will have to do upon receiving your approval. Okay.
Okay. Yeah, that's
Applicants have
interesting.
already started doing it. You may as well. You just obviously won't know whether or not you'll fully be on on the ballot as of yet. So
Sure.
it's up to you on whether or not you want to start campaigning now or when you have been given the okay.
Which and how many magistrates are you taking? If I could ask you that question.
And we're looking at top three that could be either closed or more. We could take top three. We could also take top four, but that's not up to us. That's up to the CJ, the Chief Justice. But one last question: we have three courts here: Court of Civil Equity, Court of Justice, and the Court of Review. If you were to be elected by the people, which court would you find yourself in, or would you prefer to be in?
It's a good question, Judge. I think you're asking
Do
me.
you understand each court, by the way?
Yeah. I
Okay,
understand each court.
fantastic.
I think you're asking me a question where it would be disrespectful for me to give you an answer without reasonably sitting down and thinking about this. You know it, Judge. So I think if I could get back to you on this one, perhaps send you a message a day.
All right, that's a
24
good
hours.
PR way of saying that you're going to deflect, but all right.